All right, so,
We back.
Mr. Chamberlain, where are you, sir?
Hopefully the light sound keep working. We is back though. Hold on.
I'm right here, Judge.
Sir, I'm gonna put Mr. Stillwell, number 14, on for the 15th of October, okay?
13th, Judge.
13, you're correct, sir,
13.
13.
Yes. Okay.
All right,
We
thank
back
you.
in on the 13th.
Well,
This is on 11 Alive YouTube
All right.
channel. If you want to go over there and watch it, I'm gonna have a link in the description after.
Sure.
Shout out to my nigga New Money. Let me use the spot too, man. My Wi-Fi fucked up at the crib.
Yes, sir, did you wish to remain, or you're welcome to do so, or would you like to?
We gonna do a full commentary after this, and then we gonna talk about that Memphis situation.
You're welcome to do so. Yes, sir. Okay, all right.
This is what it looked like in the courtroom, man.
Thank you. Okay, all right.
What's good? Hey, we here in court right now. Young Thug, they got multiple YSL members in there. They was this morning spending time talking about a lot of shit that was crazy. The discussion of the witnesses came up. They also discussed the discoveries being shown and things of that nature. And he told, normally it would move differently, but he told Young Thug lawyer, this is a different type of case. Like, that ain't gonna go. And I'm like, shit, everybody is looking at the seriousness of this case right now, bro. Like, this shit different. We ain't never saw nothing like this in rap for an artist that was at this high of a level. But this how the game really goes. This how this game really go, bro. It's the other side of this shit. I ain't gonna lie to y'all, bro. It's the other side of this shit. It get
Ms.
real.
Merchant, thank you to begin with for your patience with us. To begin with, and let me go ahead, and you have several motions, but can I deal with the issues involving the motion to dismiss and plea and bar, and then the double jeopardy issue? Okay, and then I'll transition into the motion to sever, and I'll let you and the others who are here, who have severance issues they want to talk to me about, go ahead and do that at that time.
And we are happy to hold on to severance issues. We were given some additional discovery by the state on Friday, which I think bears the severance issues. It was the discovery for the new indictment. So
Okay.
we've never seen that up until last Friday. I've worked through it, but there's hundreds of hours of videos, and I just
Damn, hundreds of hours of videos.
I haven't gotten to that. So
Yeah. I will let you defer that until a later time there. Okay, all right. But, okay, so let's take up, so we'll table that one, your motion to sever, I'll let the others decide accordingly whether they would like to do so as well. But go ahead and let's talk about your motion to dismiss based on statute of limitations and the double jeopardy issue.
okay, where would you like me to be?
Either way, any place is fine. You can remain at the table, you can sit down, you can come and vote, whatever you want.
Thank you. I know that courtroom logistics have changed somewhat.
Yes,
so I
ma'am.
just wanted to ask. Thank you, Judge. So
We here, y'all. We tapped in live.
Statute of limitations. I filed them under the old indictment, and then there was a new indictment, so that added some other counts. So the argument is somewhat different because of those new counts, but I want to focus on the two predicate acts that were alleged in the indictment that we believe are barred by double jeopardy in the statute.
And just to clarify, I did sign an order authorizing the current motions that were filed under the old indictment to be reincorporated in the new indictment ending in 572. So to perfect your motions and argument, we've already, that they will pertain to this indictment and anything else you have, okay?
Thank you, Judge. So there's really two incidents that I want to focus on, and I want to just talk a little bit about the facts first because I think that's helpful. My client was first arrested in a case that is alleged in Act number 11. So in the indictment, the new indictment is on page 17. It is Act
What's
number
good, everybody
11.
coming in?
It's alleged to have occurred on September 18th of 2014. That count says that as an associate of YSL, he committed a felony and aggravated assault with a deadly weapon. against a person named Michael Castellini.
Dang.
And then that is an act of racketeering activity and an overt act. So they're alleging that it's an act of racketeering and it's also an overt act. That case, the aggravated assault was dismissed, it was null crossed, and my client pled guilty to a reckless conduct. He received 12 months probation on that case. That was in
Okay, all right, go ahead.
That was in 14 SC 131032. And again, the aggravated assault was null crossed, and he was convicted and adjudicated guilty on lesser included on count 3 of reckless conduct and received and successfully completed 12 months probation. The firearm charge was also null crossed. Moving forward, he is charged then on page 22 of the indictment. He's charged in act number 29, along with a couple other folks. That act is not alleged to have been a crime. That is only alleged to be an overt act. So that's not one of the ones that we're arguing about double jeopardy pertaining to, because that's not actually a crime. But if you fast forward to page 30, acts number 56, 57, 59 are all part of an action that happened on October 1st, 2015. That case was a conspiracy to commit murder, a theft by receiving stolen property of firearm, and a street gang participation. My client is currently under first offender probation for that case. He was charged by the same district attorney's office, and he was granted a plea bargain under the First Offender Act, and he is still on first offender probation. My
It was
client
good,
is
everybody
charged
coming in.
with another overt act, but it is not alleged to be a crime, on page 40, number 97. Also on page 43, number 111, he's charged with a photo. It's another overt act, again, not a crime, not a criminal act specifically. And then page 48, he's charged in 131 and 132 with additional overt acts, not crimes, about a YouTube video and a conversation. So those are essentially the crimes that he's charged with up until the May 9th case. The two underlying cases, the 2014 and 2015 case, both of which he pled guilty and was sentenced for, we are alleging, one, should not be allowed to be used as predicate acts in furtherance of racketeering activity, and two, should be barred by the statute of limitations. So it's a
They
little
said
bit-
YouTube video. They did say
the
YouTube
argument has
video.
shifted a little bit because now they have indicted him on additional counts that happened in 2022.
Did they mean
So
Instagram or they
while I
mean YouTube?
I will
She said
agree
YouTube.
that takes the racketeering act
Dude,
outside of the
this is
statute of
insane.
limitations issue. The two predicate acts that they
We already know they got to
allege
overload the
was
information
outlined in the- talked about those
evidence.
2014.
They said 117
Those two
videos,
those
bro.
two cases that he's got probation for. We do not believe that those should be allowed to be charged as predicate acts, and that those should not be allowed to suffice as two of the crimes that have to be proven for a racketeering case. And what he's charged with, if you look back at the statute, Judge, he's charged with 16-14-4. That statute says that it's unlawful to do an act through a pattern of racketeering activity. Says you have to have, and then the definition section of that statute is 16-14-3. It says a pattern of racketeering activity, this is subsection 4A, says engaging in at least two acts of racketeering activity, and that the last of such acts occurred within 4 years. It then goes on under 5A to define what racketeering activity means. And it means to commit any crime which is chargeable by indictment. To commit, solicit, coerce, or intimidate another person to commit a crime which is chargeable by indictment. So
Thanks, William
essentially
Cole.
what they're doing is they're using two criminal acts, which he's already pled guilty for and was sentenced, and which are also outside of the statute of limitations, as the two predicate acts to bring him under this Rico statute. These are different than the overt acts. There's overt acts that they can still argue these overt acts are somehow relevant, But that's not what our issue is. Our issue is these two criminal acts that happened 9 years ago, 9 years ago, for which he has pled guilty and sentenced. And if you think about it, what's gonna happen if this is allowed to continue is in front of the jury's gonna hear, he's pled guilty and was sentenced to these acts and is on probation. So they've already gotten an admission. He's actually under sentence currently on one of them. And so there's a
I get
lot of
what you're saying.
different case law I did want to address, because the state addressed it in their response brief we received yesterday. And I did just want to address briefly, I'm not going to bore the court with double jeopardy case law because I know the court is well aware of what the case law is, but the state had made some contentions in their brief that we had somehow misrepresented what the current state of the law is. Judge, I would just refer the court to the 2021 case of Maxwell versus State. That is
Shout out
probably the
Juice.
most recent double jeopardy case out of our Supreme Court. That case specifically cites the cases that I've cited in our motion.
What's the citation for Maxwell?
Yes, Judge, it is 311 Georgia 673, and it was decided June 1st, 2021. And at the time, Chief Justice Melton found it important to cite the same cases that I cited in our motion that the state has said it was improper somehow for me to cite. On page, in that opinion, they cite Estevez, which Estevez was overturned as far as whether we use the required or actual evidence test. Yes, but they cite the exact statement of law that I cited in my argument. And I think that case, that Maxwell case, is really the most instructive. And it talks about procedural double jeopardy and the factors that must be satisfied. The factors that it talks about that must be satisfied are if a second prosecution is barred, if the crimes could have been brought in the first prosecution. That this constitutional double jeopardy protection is enhanced by Georgia's statutory double jeopardy protections, and that we have an additional double jeopardy protection here in the state of Georgia. Unlike constitutional double jeopardy, Georgia's statutory procedural double jeopardy extends the concept of res judicata to the successive prosecution of different crimes arising from the same conduct in situations where the state should have prosecuted the different crimes in a single proceeding. These were all the three things that are required. They were all known by the prosecutor at the time, and they could have been all charged in the same action. So if they had wanted to charge him with conspiracy when they charged him with a 2015 case or 2014 case, they could have. There's no additional discovery on those crimes. There's no additional information that wasn't known to them then. And so, Judge, it's just our argument that that they're outside of the statute of limitations and that they should be barred by double jeopardy. Thank you.
Okay, thank you. All right, which one of y'all is gonna argue that? Mr. Floyd? Okay,
Okay, hold on just a second.
A couple of things.
For the people that don't know what's going on, some of the, and shout out to everybody that's coming in, this is on 11 Alive YouTube channel. Which I missed was she's making the argument that some of these charges that are in this Rico, people have already either done time for, or they are already been sentenced for things like probation and everything like that. So that act of like, okay, this is a form of like you're charging them twice. She brought up her client who said that he's already on probation for something he did on a crime that they have listed in this Rico. That's what her argument is right now. So he's going to go with the defense of it. Shout out to everybody tapping in. We appreciate y'all. This is on 11 Alive YouTube channel.
Understand why we were talking about pattern just a minute ago, but it didn't need to be talked about at all because it simply doesn't apply. As counsel acknowledged, a conspiracy case can be based on one overt act by any one of the defendants. Again, that's posture. So it doesn't, much of this argument, it seems to me, is just largely misplaced. It doesn't matter to the survival of count one whether a particular act occurred more than 5 years before the indictment, and I'm going to switch to statute of limitations in a second. And it doesn't matter whether it's an act of racketeering activity or not, so long as it is an overt act. There are 191 overt acts alleged in this case. There are over 140 that occurred within 5 years of the filing of the return of the indictment. And there are, I believe, 3 against Mr. Arnold that occurred in May of this year. So as to the count itself, there is absolutely no question that it is timely.
But I think that what her argument is that in these particular counts, they're outside the statute of limitations.
Okay, and that's the next thing I'm going to turn to.
I mean, she's right. I mean, she didn't argue the overt acts. She didn't argue anything else. She's just saying that these particular acts that happened in 2014 and 15 are beyond the statute, and they fall into the issue of double jeopardy.
Okay, so let's break that down, because it is 2 separate arguments. And I'll address both of them for you, Ronnie. As to 1614.4, my point was, as to Mr. Arnold, just reading the wrong parts of the statute, focusing in on specific predicate acts for a minute. There, it's misreading the statute of limitations, which is a different provision. That's 1614.8. 1614.8 is quite clear, and it says that the statute of limitations begins to run 5 years after the conduct in violation of a provision of this chapter terminates. That's not 5 years after a particular act of racketeering activity or 5 years after a particular overt act. It's after the conduct in violation of the provision terminates. In the context of criminal law, criminal cases under Georgia Rico, that means the last overt act or the last predicate act is how you measure the statute of limitations. You did not measure it based on the first act, be it an act of racketeering activity or an overt act. You don't measure it on any intermediate act. You measure it by the end. And that's Conza versus State, which we cited in our brief, and Watley versus State, which we cited in our brief. And just to be clear on that, that means you measure it from the last overt act by any conspirator. So there is no basis whatsoever in the criminal cases in Georgia law to strike or eliminate or dismiss or whatever it is Mr. Arnold's actually asking to do. The word dismiss was used. You don't dismiss individual predicate acts, you dismiss counts. The count is absolutely timely. For less than 3 months ran between the last overt act alleged in this indictment.
Okay, what about
and the return of the indictment.
What about our argument in terms of double jeopardy?
Okay, the argument in terms of
Answer
double
that.
in terms of double jeopardy is a little different, and it takes a moment to explain. And we again filed a separate brief on that yesterday. So Rico is a somewhat different kind of animal. And the case that Arnold originally relied upon was a case called Martin versus State. That was a case out of DeKalb County. And in that case, DeKalb indicted up to 2 Rico counts, substantive, and then every act of racketeering activity was separately charged as an individual freestanding count. Defendants were convicted across the board of everything. They appealed, and using the rule that then existed, which was under a case called Estevez, State versus Estevez, and another case called State versus Haynes. The Court of Appeals looked at the situation and said, number one, we recognize that our rule is different. The federal rule is different. And it looked at a case called United States versus Phillips in the circuit. Phillips applies, and there's a lot of cases in this chain. Phillips applies a case called Blockberger, the United States Supreme Court case from 1932. Blockberger says to determine whether 2 acts of the same offense, you look at the elements. If each has an element, the other one doesn't. They're 2 separate crimes. can be convicted. I'm sure you've seen Walkberger in the past in other contexts.
Yeah, in law school.
Okay, well,
And then some.
right. And so, yes, it is kind of Oreo law. Right? And so Phillips was an 11th Circuit case that looked at that in a RICO context and said, yes.
Shout out to everybody that's just coming in. If you're just coming in right now, shout out to 11 Alive YouTube channel. Right now, he's making an argument about them being able to use the crimes that that people in the YSL group have already been sentenced for, or that they've done in the past with statutes of limitations and everything. So what he's saying is, with statute of limitations, that doesn't start. And he named the case name, I forgot the names was. He got this whole book, and how they be doing this shit. They combat the casings and the rulings according to other cases that have happened in the past. I know some of y'all already know this and everything like that, but this is for the people that don't really be knowing how this stuff works. So he's going to read all these other things that say, hey, his statute of limitation on his 2014, he was sentenced a certain amount of years. The statute of limitation in this case won't start 5 years until after he's off of probation and everything. It don't start from the date you committed the crime. It starts when your crime is over. That's what he said, once your time is served. You know what I'm saying? Or things of that nature. But to my knowledge in this shit, I don't know how it works in the Rico, but in the state, if you statute of limitations and double jeopardy, I know there's no double jeopardy on murder. You know what I'm saying? Certain cases, certain situations, double jeopardy can come into play. This Rico is getting different though. This Rico is crazy, it's different. We go back to it. Shout out to everybody that's coming in. It's on 11 Alive YouTube channel.
You could be convicted of both the underlying after racketeering activity and of a RICO violation. Martin looked at that and said, of an act of racketeering activity, and the government indicts and alleges that as a predicate act or an overt act. That's what's happening here. Or he's charged separately with the underlying predicate acts and a RICO in the same case. Or he's actually been convicted of a RICO first and later gets charged with the predicate acts. All of those combinations have come in the federal courts. In every single instance, the federal courts have said Blockberger does not trigger double jeopardy here because a RICO case is a special kind of case. It's a particular kind of continuing offense. And that is particularly true in the context of a conspiracy. Nothing about any of these underlying offenses, you didn't hear any argument whatsoever that any of the previously convicted pled to offenses involved an enterprise of any kind, which this does, that they had to involve acts of racketeering activity, which this does, or that they involve a conspiratorial agreement, which this does. And so there is one conspiracy to murder charge, which was mentioned, but that's a different kind of conspiracy. And so the reason that you don't have double jeopardy here, and Blockberger is the controlling test. The Court of Appeals used it in an appeal out of the Atlanta Public Schools conviction very recently in a case called State versus Cotton, a RICO conspiracy conviction, and said no double jeopardy. And it did the Blockberger analysis. And the point was the underlying offense is not an essential element of RICO, because a RICO could be based on any one of 70 other types of underlying activity. The RICO, in expressly both Cotton and a prior case called Redford, Georgia has aligned itself with the federal cases to say that acts of racketeering activity are not lesser included offenses. And so you come down to the fact that they are just plain and simple different. And in fact, even in circumstances where defendants have been tried and acquitted for an underlying case, which of course can also apply double jeopardy. That conduct can still be used as an act of racketeering activity or an overt act here. And the important thing, following up on what I've said about the structure of RICO and why it's different here, Your Honor, is that Mr. Arnold is not going to be separately convicted of the acts he's talking about. They are not freestanding counts. He will not be, if convicted, separately sentenced for those. So he will not be sentenced again or punished again. This is, in effect, evidence of how the RICO can be proved. Now, we have cited for you in our brief a series of cases as examples of this, which include,
Hold on, y'all.
just a moment.
This is crazy, bro. This is what niggas really be going through, though. I ain't gonna lie.
921 F. 2nd 1523, an 11th Circuit case. In that case, prior convictions were introduced to prove the essential elements of a RICO conspiracy.
So, hey, until he done talking, because he got like this boring undertone, bro, which a nigga don't want to see nobody in court, period. And not saying it's entertaining, but I think that him on here talking is dry and boring. All he's doing, and we gonna go back in once he actually moves on. He's reading the different cases that make it okay to push this line of the fuck, I lost my train of thought. Statute of limitations. Statute of limitations, my bad. He pushing the statute of limitations. So once he get off here, once he get off, we gonna go, bro, because I think he just got a boring underlying tone, and it's not meant to be entertaining. But he is pulling up all these court dates that suggest, in this case, the time frame they're using for these crimes. Hey, in such and such versus the state, this person with a death on a conspiracy to a death, the statute of limitations will work here. This will be within the statute of limitations. So that's what line he pushing right now. And it's just, he kind of like, he gonna make people click off, just listen to him talk. I really want to hear what the judge got to say once he done, because at the end of the day, that's who make the final decision. Young Thug is in here. Duke was in here. Some other YSL members is in here. Yak Gotti was on camera also. And man, here we go again, bro. Here we go again. So we here, man. It's a tough situation, dog. This the other side of this game, though, nigga. This is what it really looked like inside the courtrooms, nigga. Especially right now with the COVID shit going on. But normally niggas will really just be sitting in that hole. They whipped that shit up fast with the cameras, huh? Like, the pandemic in court, they really just rearranged their whole court system. But niggas would normally be having to sit in court while all this shit going on, listening to them talk and what they got to say. We have not started trial yet. Shout out to everybody coming in. They're trying to keep the witnesses' name hid. They don't want the witnesses' names to be out. for everybody coming in, I'm going to put him back on talking in a second. He just is arguing his point why the statutes of limitation law and things like that are not in effect here. So I want this to be known that it's so much underlying shit and so many little small details that go with that shit with double jeopardy, statute of limitations. Their defense is saying, hey man, on this Rico, some of these charges that are brought up in this Rico, why are they in this Rico when these dudes have already been sentenced for these crimes? Some of them have taken probation, some of them have done time already. But these cases are still in this Rico. That's what she was arguing. So I think he's done. Let's see what they got to say. Oh, he's not done yet. I guess he on his closing argument, y'all. He on his closing stuff. We'll get back to it. He was kind of like putting everybody to sleep. So I just wanted to come tap in real quick and entertain.
The arguments that were made to you relied principally on Martin versus State. And the fact of the matter is, it just comes down to this. Martin has been dead and gone for 16 years. It is not the rule. And if you go back and read Martin, it is abundantly clear that had Blockberger been the rule, the result in Martin would have been the opposite of what it was. That is the result that it should be today.
All right, thank you, Mr. Floyd.
Thank you, Your Honor.
Okay, all right. Ms. Merchant, any rebuttal?
Very briefly.
All right, go right ahead now.
Thank you. Judge, I wanted to respond.
This is their defense.
Began its argument that pattern of racketeering doesn't apply here. This is a conspiracy. They said it doesn't matter as long as there's an overt act, and that I'm basically reading the wrong parts of the statute. Judge, I tracked it based on their indictment and their language in the indictment. On page 12 of the indictment, when they actually allege the act that they're charging, they charge 16-14-4C. And they specifically state that my client conspired, well, they say a lot more than just conspired, but through a pattern of racketeering activity in violation of subsection A, which is the one that I quoted earlier. And, in the conjunctive, and while associated with an enterprise, did unlawfully conspire through a pattern of racketeering activity in violation of B. So they have charged him under this statute that I was citing to 16-14-4. They say the charge is C, and then they say that C is based on A and B. So if you go and you look at all of those, C says it's got to be a conspiracy to violate either A or B. Both A and B say it's got to be an enterprise, a conspiracy, whatever you want to call it, through a pattern of racketeering activity. Then the definition section 16-14-3 defines a pattern of racketeering activity. Subsection 4A, engaging at least 2 acts of racketeering activity. Why is this important? Because there's a big difference between predicate acts of racketeering activity, conspiring to commit those acts, which have to be a crime, and overt acts, which do not have to be a crime. They specifically charged him in the indictment under act number 11 with aggravated assault, which is in violation of an act of racketeering activity. And then they cited this definition section as to what racketeering activity, again, a crime. So overt acts are not necessarily crimes. Without predicate acts, overt acts don't get you there. So they need predicate acts. They need 2 or more predicate acts in order to get my client under the web of this case. And the 2 predicates that they're using, and again, as I said earlier, up until the May 9th stuff, which is different, and I'll address that in the bond motion, but the only way they get there is with these 2 predicate acts. So while before they re-indicted it, I asked for the entire indictment to be dismissed because I believe that was appropriate. Because without the 2 crimes that are both barred by double jeopardy, all they had was he posted a video on YouTube and he was in a picture on Instagram. So they had no crimes with my client. Now they've got him in a home on May 9th, so that's a different story. But we still believe that these 2 predicate acts should be barred from being used against him to show a pattern of racketeering activity. This is a broad statute. It's a very, very broad statute. But you have to prove something. And you have to prove that you did 2 crimes. And then you got to, for the pattern. That's how it's narrowly tailored to make sure that we're not just locking people up who are associated with criminals or alleged criminals or whatever it is. And the fact of the matter is, the two crimes that he is charged with committing, he has already been sentenced for and pled guilty to. This DA's office has agreed to probation on those and misdemeanor on the other one. So those should not be able to be used against him, Judge. I wanted to go into the May 9th stuff for bond, but I assume you want me to wait on that?
But in terms of your client for bond,
Yes.
let me first button up this thing, the issue of emotions, and then I'll turn to the bond, issue of bond. Mr. Floyd, anything else you want to respond as to?
I'll be I mean,
All right.
in this motion,
This dude here is like a slow talker, bro, and it gets boring when he talk because of his voice. He talking what he talking is shit that is very important that he's saying. Just his delivery be dry and shit like that. So basically, she's saying,
strategy of
hold on, just a second.
in this case, that was affirmed in the language is a right.
She's reading off what they're being charged with and talking about the statute of limitations on some of these crimes that they are faced with in this indictment. The bond conversation is about to come up, so we about to get to talking about the bond in just a second. You know what I'm saying? The bond conversation gonna be coming up. But he trying to go against her defense now because she came back and dug some shit up about the statute of limitations on these crimes that people or her client that she's defending on the YSL Rico, like, hey man, he already got sentenced for this shit. He already got charged for this shit. Why is this affecting a bond now? And why is this part of the Rico charge now if he's already been sentenced for it? So now this guy here is reading his side and coming with his defense. I only not playing him because he say it's gonna be quick. We'll see. That nigga is boring as hell when he speaks. So as soon as he done speaking, y'all want to listen to him talk? What y'all want to do? It's on y'all, man. How y'all want to do it? What y'all want to do, bro? She's attacking the terms of statute of limitations of some of these charges. But everybody in the chat, like I say, this guy here, he's sitting down. We good. We back on, man. We good. That nigga that be kind of dry. Let's see what she say. This is her defending.
Twice in the conjunctive on page 12. That's how they charged him.
She said twice is how they charge him.
Okay, I see it. All right. Okay. All right. Let me consider this, and then Ms. Merchant, I'll turn to your issue of bond. Okay. All right.
So she trying to get the bond.
Okay. Both of you filed quite extensive motions and law on this particular issue. Both issues, a motion to dismiss and on the based upon statute of limitations as well as double jeopardy. And the court's had an opportunity to consider your pleadings as it pertains to both issues. And in particular, it's had an opportunity to take a look at Maxwell versus the state 311 Georgia 673, as well as Martin versus the state, Estevez, Hayes, Drinkard, and Cottman. And Cottman is our Supreme Court's most recent pronouncement in regards to Rico and analysis, as well as gives the court some guidance in that respect. Mr. Floyd, you did a fine job. I felt like a second officer in terms of laying out the blockbuster test in our court's distinguishment of that along with the 11th Circuit's issue. So I'm in agreement with you about that in regards to
We gonna see
how our court considers double jeopardy and Rico and conspiracy. And I have read it and do agree that Rico's a particular compound offense takes place over time and the aspects that are at this point in time that you all have in your indictment that you have to, of course, have to prove, but that I'm going to, based upon what I've read so far, I'm going to deny the motion to dismiss and plea and bar based on statute of limitations, and also deny the motion to dismiss the indictment on double jeopardy grounds at this point in time. But well argued, well briefed, very interesting.
Well,
If I'm wrong, our appellate court, I'm sure will tell me. So, Ms. Merchant, let's move to your bond hearing at this point in time.
Thank you so much.
And Mr. Floyd, I will leave you with the responsibility of preparing or you, your team, a suitable order. Send that to Ms. Merchant, of course, for perusal, and then send that to Mr. Kearns.
here we go. We finna get into the bond right now.
For my reading and edits again, okay? All right, if you could do that by today is about a week from now, did I give you that time?
They don't get a
Okay,
bond
so
today. They
let's
got
do
another
the
trauma 15.
Great, thank you so much.
Yes. You may say.
His mic low.
Okay, madam, go
Great.
ahead.
Thank you, Judge. Before I get into the main part of my argument, I want to let you know where my client will be living if he is released on bond. I'm not going to give the address publicly if that's okay with the court.
That is fine.
I'll be happy to provide it. It's with his mother, who's actually outside the courtroom. He's got quite a bit of family members outside the courtroom. I guess they have an issue with having an ID and coming to, they're watching the public proceedings.
Do they have, is the
The screen's on, so they're
Don
watching.
outside my courtroom?
It is, yes.
Yeah,
They've all
fine,
gathered
sure.
right there.
Okay, all right, want to make sure, okay.
Yes, and they're hearing and seeing it fine. I just wanted to let you know that they were all here. Oh, there's his mother.
Okay,
They were all here. So it's clearly working. They heard me ask for her.
okay,
But he went to Carver High School, Judge. His mom, the address that he would be living at, has lived there for 10 years with his grandmother. His sister is also in the area. Her name is Jaquita Arnold. She's a manager at a local Walmart. So he's got ties to the community, Judge. I think what the big issue for the state was originally in the court
This is Duke
was
lawyer.
his criminal history and these charges. And
I
so I
think-
want to focus my argument on both of those. Judge, you've already heard our argument about the double jeopardy, so you know about the two prior crimes that are serving as the two predicate acts. But I want to talk about the other things that he's charged with here, just so that you understand fully, because it's hard for me to separate when you lump a lot of things together. So I want to make sure that you understand what he's specifically charged with. Outside of those two predicate acts, the one that he received a reckless conduct plea for and the one he received first offender, he's charged with an act of posing for a photo on a Mr. Garlington's Instagram account. That is an overt act. He is charged with another overt act of appearing in a YouTube video where I believe it looks like somebody is rapping and he's on the video, a public YouTube video.
This is crazy.
Another overt act is that he posed for a photo on his Instagram account, and he had
This might be
a
good.
shirt that said slime on it, and that's an overt act. Then he's charged with one other YouTube video where there's apparently some rapping going on, and he's in that. And then there's an overt act number 132. It says that he engaged in a conversation where Mr. Williams made some statements, but doesn't say anything about how Mr. Arnold participated in this. Just says that this was an overt act that Mr. Williams made some statements during this conversation. Up until May 9th, that's the gist of what we had going on in this case. May 9th, when he was arrested on the grand jury warrant, they raided Mr. Williams' home. We were provided that discovery on Friday, and I was able to go through it. It was very enlightening. My client is charged with several counts with that, but I think that the counts are somewhat disingenuous. In count 57, he is charged along with Mr. Kendrick and Mr. Williams with participation in the street gang for having marijuana, cocaine, and a firearm when the house was raided that day on May 9th.
Okay.
He's charged in number 58 with possessing marijuana with intent to distribute. Okay, so the street gang charge is based on all the individual charges. So I'm gonna tell you about the individual charges. So marijuana with intent to distribute. Marijuana was found in a cabinet above the fridge, a kitchen cabinet. It was not in plain sight. It took the officers actually searching the home to find it. This is not Mr. Arnold's home. There were 20-something people that were taken outside, and on the videos, which I've arguably only gotten through about 8 of, on the videos, they knock on the door, SWAT raids the house, they take everybody outside, okay? So everybody's outside. Mr. Arnold's in a police car. Then they go in the house. The only thing they see when they go in the house, in plain view, they say, is a gun on a kitchen counter. There's no mention anywhere about where Mr. Arnold was in this house. This is a big house. Where he was, if he was even in the kitchen. You come in my front door and you're in my dining room and my living room, you don't see my kitchen. You don't even go to my kitchen. Marijuana, 1,299 grams. Inside a kitchen cabinet above a refrigerator. Closed. Officers didn't see it.
Arnold Martin.
Codeine.
Yeah, they talking about Duke. This is Duke, Lord.
In a secret compartment. The police report says it was found in a secret compartment. Not Mr. Arnold's home.
Dang.
Count 60. Possession of cocaine. Again, secret compartment. Count 61. This is the firearm count. So there's quite a few they've lumped in the same count, so I'm going to walk through where all these guns were found. I think it's very relevant. The state indicted and told the grand jury that Mr. Arnold had on and within arm's reach a Glock 30S. That Glock 30S was actually found in a secret compartment in the pantry. They said that he had on and within arm's reach a Glock 357. That was actually found under a bed in someone's bedroom. They said he had a Glock 19. That was actually found inside a closed kitchen cabinet. They said he had a Smith & Wesson M&P, and he's also charged with that, because that's a machine gun, in count 62. They said he had within arm's reach or on his person, but yet that machine gun was found inside a kitchen cabinet. Finally, he's charged with a Glock 45. That Glock 45 was found downstairs.
Duke might get a ball, y'all.
That was in what could arguably even be called plain view in that home was an FN, which is registered to a Shazmeen Carroll. There were 20-something people at that house. You can hear, if you listen to the police talking, that the people felt they could arrest for the guns and drugs, or either people on the grand jury warrant or convicted felons. My client's manager was there, and the cops are talking about how we need to run his history to see if he's a convicted felon so we can tag him with these things. The only reason he was charged was because he was present in a home that these items were found. There is absolutely no evidence he had a clue about any of these items. So these are all the new charges. You know what he did have on him? He had 3 grams of marijuana. That is 0.1 ounce. That is well below the legal limit. That's what Mr. Arnold had on. So
His name
the
Martinez
state, I
Arnold.
believe, will argue that all this supports that he's part of this criminal conspiracy and that he's a bad guy and shouldn't be released on bond. But the truth is, the San DA's office believed a few years ago that he should be on first offender probation, and he has successfully been on first offender probation. He has several marijuana arrests. He has been arrested. Every single one of them was dismissed, except for the ones I'm about to tell you about. In 2005, he had a forgery that he got PTI. It was dead docketed by Judge Schwab. In 2007, he completed 12 months of probation for a disorderly conduct. Successfully completed. Successfully appeared for court, successfully completed probation. In 2020, he successfully completed 12 months of probation for marijuana less than an ounce. In 2015, one of the cases that we talked about in the Predicate Act, he successfully completed probation for 12 months for a reckless conduct charge. All of the felonies were dismissed. by the same prosecution. In 2016, the same prosecution agreed to first offender probation. So you can't say he committed new crimes while he was out on probation, because the crimes he's alleged to commit in the indictment are the crimes that he's on probation for.
Duke might
He
get a
has been
bond.
successfully on probation, on first offender probation, where it is watched, he is watched, and he has not failed to appear, he hasn't failed to appear in court, he hasn't committed any new crimes, hasn't done any of that stuff. He's being charged with the crime he already committed. Well, arguably, in all fairness, he had 3 grams of marijuana on him on the night. So he did commit that crime, because that is still a crime in Georgia. So arguably, he did commit a misdemeanor of having marijuana on his person on May 9th when he was arrested. But that's it. He is not a convicted felon. He has significant ties to the community. We believe he is not a risk to flight, not a risk to intimidate. There's been no allegations that he's intimidated anybody. He's not part of that. Whatever those allegations are, we're not privy to any of that. And so we don't believe that it's fair to lump him into that, because the case against Mr. Arnold is very, very weak. And leaving him in jail without a bond while he's waiting trial is unfairly punishing him for something that he is very likely not going to be found guilty of, Judge. And so we would just argue that he should be given bond. We ask for $50,000 and a fine, house arrest, whatever satisfies the court's concerns for him. But he's not a risk, Judge. Thank you.
Duke might get a bond. I ain't gonna lie, bro. This is the first
All right.
time where I felt they have leverage based off of what she broke down. This nigga Duke got a hell of a lawyer, boy. We finna listen though.
For the following reasons. I would submit to the court that Mr. Arnold, he's a documented YSL from 2016, I believe it is, wrong. I would submit to the court that the defendant poses a risk of committing additional felonies pending trial. As counsel pointed, the defendant was indicted. He was charged with only 1 count of racketeering. Following his arrest, as counsel also pointed out, he was charged and subsequently indicted with 6 additional felonies. Those are counts 57 through 62 of the current re-indictment, Your Honor. Those additional felonies involve possession of drugs and possession of firearm and
Well, in his
possession of
house.
machine gun. The counsel didn't point out that those are distribution amounts of drugs that he was possessing.
What the 3 grams of marijuana? What is that? That's what was found on, right?
That was found on him, but within the home, there were distribution amounts of marijuana as well as.
That's Mr. Williamson, right?
That's correct. Mr. Arnold was not just merely present in the home, Your Honor. He had a bag that belonged to him within the home. And at the time, when officers were attempting to search the home, well, when they came to knock on the door, it took them a while to answer the door, Your Honor. They could have hidden the drugs and everything at that particular time.
Nah, that ain't gonna work. They don't even sound right. I ain't gonna lie, Duke might be finna get him a bond, nigga.
That was the Glock 45. I think counsel inappropriately or incorrectly indicated that the MP was a machine gun. It was actually the Glock 45 that was a machine gun. Based on the facts and
Is
circumstances.
that on him or was that found in the home?
That was found within the home, Your Honor.
Was it
Okay.
within his arm's reach, or
If I'm not mistaken, I believe it was within the county area.
what county you're from? What county?
The Harmon area.
What county is that, sir?
What county is it, nigga?
62.
Look, that nigga getting nervous. Look, that nigga about to fuck up. Duke finna get out that hoe. This shit crazy. Nigga watching this shit live. Nah, bro. If you been listening, Duke finna get out, bro. He supposed to get out. That nigga lawyer broke that shit down. Nigga like, hold on, this. Duke might be the nigga that come home, bro. On the cool. Duke finna probably get out this shit. I don't know about Gunna. I can't speak for Gunna. I can only speak for Duke.
Okay, so tell me about the circumstances of 62, count 62. Is that, was that the arrest, of Mr. Williams' home or what?
Yes, that is the rest of Mr. Williams' home, Judge.
Okay, was he found with his firearm on him, or was it on the streets, or was it in the home?
If I'm not mistaken, it was within the home, within the streets.
It was downstairs, it's in the first floor.
Is that true, Mr. Smith?
Well, they had been found downstairs, Your Honor. It was obvious and it was open. It wasn't hidden or anything like that. It was an open area, obvious.
Okay. While they doing that, let me tell y'all what's going on. For the people that just coming in, this is on the 11 Alive YouTube channel. Duke lawyer, YSL Duke, his lawyer just spoke on his behalf and basically been pressing the line that she wanted statute of limitations on his charges to be used against this and everything like that. She got denied on that for those the double jeopardy and statute of limitations because everything he's charged with that ties him to this YSL as far as a crime, not affiliation, not pictures. What is tied to him as a crime, it's already been gone over, but the judge didn't grant her that request. Now she's saying, why is he not getting a bond? He has one count on this. His criminal history is all marijuana charges, and he's not a convicted felon. And she also said they were not in his home. When they got arrested, the new indictment that he is in, the gun is not in his name. The gun is not in his possession in his house. He had 3 grams of weed on him. So with that, y'all say he can't get an indictment. He's not appointed as a leader. He's not appointed as a shooter. All of his probations have been, taken off his record. So that's why she said, I'm thinking Duke might get a bond. Duke is not Young Thug older brother. That's his homie. He stopped. You see how he looked up?
Who is that case with at this point in time? Which one of my colleagues was that with me?
YSL Duke. I know he had that song called Bitch Pressing. They got music. He got a lot of music. He one of the known members of YSL. Yeah, Duke was arrested with Young Thug. He was at the house. It was Thug, Duke, Yak Gotti, and one more dude that I don't know. But Duke was there with him. But it looked like Duke finna get this motherfucking bond today.
That one is sealed.
He completed?
No, he's currently in process of
That means he's still on probation.
Correct.
Who has that case? And I'm just going to understand probation.
He's not. He successfully completed that probation, that's by seal.
Okay, so he's finished that particular period of probation that he was sentenced on in 2014. Is that correct?
It was 2016, Judge?
2016?
Yes, and he has successfully completed that probation, Judge, and that is the predicate act in count.
I ain't gonna lie, man. Duke might get a bond, man.
That's one.
Duke supposed to get a bond.
Okay, all right.
So there was no revocation, it was the same offense, but, so it would have been like subsequent to probation.
Sealed. We'll see. If this is a regular case, he most definitely
Yes,
get a
yes,
bond.
absolutely.
I represent to the court that based on the fact and circumstances of this case, those are risks to the community and to the maybe witnesses.
That ain't gonna work.
First appearance.
No.
Citing basically that he was a risk to commit a vicious felony.
Can't say that, nigga. He don't got no. He got a not convicted felon.
Citing all guys out of that basis for denial. There has been no change circumstances, Judge.
Nah, they lost this one. I think Duke finna come home.
So you specifically say he's a risk to the community. Any other things that?
and risk of intimidating witnesses as well as the risk of.
That ain't gonna work.
Has he contacted anybody since this indictment in jail or in any other location?
To my knowledge, Judge.
Not to, hey, Duke, hey, they scrambling, bro. This shit crazy. Watching this shit unfold, bro, because the nigga was like, I don't know what they gonna do, but in Duke case, nigga, Duke, y'all hear that noise, bro? Come on. That's that nigga, they cleaning up some shit next door, my nigga crib. Shout out to my nigga New Money for letting me use the crib, too. My bad for talking, man, but I gotta make it interesting. Hey man, they ain't got it, bro, on this Duke situation. Nah, they trying to scramble because I ain't gonna lie, Duke lawyer done broke this shit down. Is it too loud? Is it too loud? We ain't tripping on the copyright claim. Shout out to 11 Alive. Y'all go subscribe to them. This is for the content, bro. Oh, you talking about, oh, okay, yeah. I know what you're saying. Okay, y'all want me to keep talking my shit. So for people that just came in, Duke lawyer is really doing her shit. Martinez is his name. Martinez Arnold. That's Duke's name. Hold on. Okay, I don't want to interrupt him and see what he's gonna say, but she presented these statute of limitations on his charges with YSL are already up. And she also was talking about double jeopardy. The judge said she can't get his.
Judge, can I add just two things?
They lost this one.
Act 11 that counsel points out. I just want to briefly give you some background as to the allegations in that.
Bro,
Facts in that particular
this
case.
it don't make sense.
Shooting in public in daylight.
He didn't do the shooting, no, nigga.
Particular case, I believe, if I'm not mistaken, it was at Lennox Mall.
Shit, it's count 11.
Yeah, that not count 11, Act 11.
Is it Act 11?
Act 11.
Okay.
And then combine in Act 56, some of the background of that conspiracy to commit murder and that gang charge. He was actually apprehended in rival gang territory in the process of going to basically commit murder in retaliation for a shooting against a rival gang. And for those reasons, I would respectfully request that you not defense counsel motion for that.
Yeah, bro, they don't got it. I ain't gonna lie to y'all today.
Okay. Ms. Merchant, you want to address that? I'll give you one more opportunity to address that issue. The state's basically saying he's a danger to the community. I mean, because what's proffered, not proven, but proffered at this point in time is in count 11 is some fairly serious conduct, as well as predicate act 11, I should say, and predicate act 56, which involve use of weapons. So you want to address that?
I do, definitely, Judge. Judge, this same prosecution office dismissed the aggravated assault with a deadly weapon in count 11. They null-crossed it back in 2015. I believe it was February 2015. That's in case 14 SC 131032. So I know that now they're arguing that it was serious and he was dangerous, but they dismissed it. And
Well, that could be any number.
it could be, but they agreed to a reckless conduct plea of guilty. And then subsequent to that, they offered him first offender probation. So if they dismissed it because the evidence was weak or whatever, then they also gave him first offender probation just a year later. So one would think that if he was such a threat to the community and so dangerous, that he would not then get first offender probation less than a year later.
Once the court's decision, of course, the state gets an opportunity to weigh in, so does your client, so does your, the accused, as long as they're not statutorily prohibited to be having taken first offender some other place, location, basically anywhere in the world. Then the court can, depending upon the facts, determine they want
Good point, Courtney Southern.
first offender sentence.
I'm glad you pointed that out, Judge, because it's even better. The judge found that he was eligible for probation and sentenced him to probation and found that that was appropriate. So he was an appropriate candidate for probation. If you are a danger to commit felonies or intimidate people or, wreak havoc on the community, a judge and the district attorney both were in agreement that he should receive probation after this 2015 case. So the 2015 case that serves as Act 11, which they're saying, shows that he's this dangerous person, he gets a guilty reckless conduct in that. So then we move on, and in 2015, he's arrested, and he takes a plea in 2016 to the first offender. He's given 5 years probation and successfully completes it. So everybody was in agreement after all these acts had happened that he is a great candidate, and he was a great candidate for probation. He did exactly what probation is designed to do. He successfully completed it without any infractions. The judge, one thing I did want to just mention, the state said he had an FTA in 2016. A quick check of the clerk's file will show that that was dismissed because he was not sent notice. So it was actually set aside. So that was not his fault. And I don't believe that that should be used against him since it was not his problem. And it was not his fault that he was not sent notice. It was quickly set aside, and that is the case that he received first offender on. So I just wanted to make sure that was cleared up. The court had some questions about the guns and where the guns were found. Again, there was nothing found on him other than these 3 grams, which is 0.1 ounce of marijuana. Thank you.
Yeah, bro. The judge, it's on his hand, but bro, if they was playing fair, if we was playing fair, bro, he really supposed to be able to go because the other judge already granted him bond. How you gonna say I'm
Just give me a second, sir.
Okay, he waiting to read it. My thing is this. They
Chairman,
trying
the motions now at this point in time, Mr. Merchant. Okay, all right. Mr. Smith, make it brief.
I ain't gonna lie, bro, that shit don't work.
All right, I'm gonna just take a few minutes. I need to take a comfort break, and I'll come back and I'll give you my decision. Okay? All right, we're in recess.
All right, they doing the recess. All right, let me chop it over with y'all. So for people coming in, Duke, YSL Duke. If you type in YSL Duke, he got music with Thug, everybody, he always around. He was on the video with them. He was on the video with them when they got arrested. It was Thug, it was Young Thug, it was Duke, and it was Jack Gotti at the house. Those are the rappers. The 4th person I don't know. So Duke actually has a very good lawyer. If you've been watching, since she came in and spoke, she got her shit together. Whatever her name is, you should pay her very well, especially if you get a bond today. I ain't gonna lie, this will raise her rank up as a lawyer because her first arguments were, hey, Duke, the things that are in this Rico, she tried to get him dropped from the Rico all around. And for everybody coming in, this is on 11 Alive YouTube channel. This is where we streaming it from. They in the courtroom right now. Everybody been in there today. Yeah, the blonde lady. So she tripped him up. He didn't know what to do. The brother, you lost to her today, my boy. She had her shit together. She tried to get him taken out of the Rico all around. Trial is supposed to start in January. She tried to get his charges dropped on statute of limitation and also double jeopardy. The things that are brought up in this Rico are things that he's already been convicted of. He's not convicted of anything new. So she tried to get him dropped from the Rico charges based on that. The judge did deny that. The judge denied that. So now we get to the point where she's trying to get him a bond. Her point is, how can you say he's a detriment to society and he will harm and do this? He's not a convicted felon, and all of his charges were weed charges. That's all his stuff. The gun case that he caught, which that's the one he was involved in with Yak Gotti, they gave him probation on that and let him come home. By him being able to come home, her argument with the judge is, hey man, if he's such a problem with society, why would they come back later and give him probation on that charge? You're not going to let somebody come home and not go to prison if there's such a problem with society. Now, what she did get the judge at, the judge was in agreement with her, the new charges on the new indictment. If y'all know, Fonnie Willis had the original indictment. It went viral. Everybody saw that original indictment. For everybody coming in, they're on break in the court right now. The judge will come back and it's going to continue right here. It's on 11 Alive. But they caught the original indictment. That's the one that went viral. It was all over Twitter and Instagram that everybody could see. He's in that one. But when they got arrested at Thug House, she came back last month with the second indictment, the machine gun. And the actual machine gun was a Glock with a switch on it. I've had this argument with niggas before. They don't like to listen. Niggas don't research and don't be knowing shit. And like I told y'all, if you get caught with a switch, hey, your ass is grass. Any heavy modifications to the sound of a gun or how fast or the movement of a gun, you will go down. Silencers, you're going to the feds. A switch on the gun, you're going to the feds. Understand that. That's what I want niggas to understand. I know it sounds cool in these rap songs. You ain't gonna get 10 alligator racing, but you gonna get some time if you got a switch on your gun. You're going down. You got a silencer on your gun. You're going down. You know what I'm saying? Damn, that's crazy. I don't know the time. You know, the lawyer, if you got a good lawyer, you might be able to get it reduced. A prime example, Kodak Black brother. I forgot dog name. Kodak Black brother, the one that used to be with him all the time. Kodak Black. His brother caught that motherfucking charge, man. He shot a music video with a silencer on it. Look that shit up, bro. Kodak Black brother shot a music video. Matter of fact, I'm gonna play it real quick while they on recess. I'm gonna use it's a Say Cheese interview where he explained it. We'll be right back in the courtroom for everybody that's pulling up. We'll be right back. What's Kodak Black brother name, bro? I fucking forgot. Let me look it up. You put a silencer. Because he had a silencer, it might come up like that. Silencer. John Wick, that's his name. On Instagram. Listen to this shit, bro. For everybody coming in, we gonna go back to the courtroom. We gonna go back to the courtroom in just a second. They are on recess. Yeah, John Wick. I knew the nigga John Wick. But bro got caught with a silencer off of Instagram, nigga, and had to go serve 2 years. Let me go back to that motherfucker. Hold on. I'll share this shit instead. Hold on. I'm gonna come back to it in just a second, y'all. We're gonna watch this real quick, and then we'll come back to the court case. This on Say Cheese channel.
Everything I do is the street.
We're gonna go back into the courtroom in a second. They're on recess.
Yeah. You know the feds do that to you, feel me? Yeah. Now, you went to the feds, you were originally sentenced.
Damn, my bad, John.
36 months, 36. They were trying to give you 10.
My bad.
They tried to give you 10 years. Yeah. Yeah. For a silencer. For what exactly? For a silencer. A silencer. Yeah. And
Bring it back, y'all.
You went to the feds. You were. Yeah. Now, you went to the feds. You were originally sentenced to what? 36 months. 36. They were trying to give you 10. They tried to give you 10 years. Yeah. Man. For a silencer. For what exactly? For a silencer. A silencer. Yeah. And did they catch you with this in the vehicle, or? They ain't catch it on my person, my vehicle, nothing.
Is it still too low?
On IG.
Picture on IG. He never even got
So
caught with that.
Real when they say watch what you post. Hell yeah. The hip hop police out here, bro. It's the federal government. You feel me? Yeah. So do you remember the exact post they saw it on?
Wasn't even
I
his
remember
gun.
the exact post because the day it was posted, I posted it like a couple days later. They didn't get it off my IG. They got off somebody else's IG. You feel what I'm saying? So it was like, they say they were looking for me for like 6 months, 7 months.
Can y'all
I
hear?
didn't know about it. Cause I was so much focused on rap, doing shows, recording video. I didn't know they were looking at me, watching me till I found out it was too late. That's why I did fast watch. And it's not like you was on the run or running from anything. You was living your everyday life. Everyday life. And did they show you the post, or was it any way you got out of it? Shit, they showed me the pictures, they showed me a couple videos of me, little spots I mean, you feel me? But it's like, I was never indulged in it. You feel what I'm saying? I'm the rapper. What I'm doing, I ain't selling drugs, I ain't selling guns, I ain't shooting nobody. You feel what I'm saying? So, you feel me? Everything I do is the street. You feel what I'm saying?
We're gonna get back in the courtroom in just a second, John.
A fake. No, they pulled out the serial number, put that bit zoom in my face. I'm like, dang. That shit got real, man. That shit got real. Real shit. Yeah. Man. And is this because it's a silencer itself? Because you know they're illegal, or is it because of it wasn't in a database. You feel me? The firearm database. It wasn't in their database, so they felt like, okay, this is a gun that's on the streets and we don't know about it. You feel me? And it was used in a sale or whatnot, or something happened. You feel me? I don't know what happened.
Now see how deep this shit get.
So at the end of the day, when they found the gun, it was not only, it was at Woo House in Golden Acres. You feel me? So I took it upon myself like, okay, it's at Woo House, how the hell I'm getting charged for it? You feel me? I don't ask him that, but that's what's going in my head. Like, man, how am I getting charged for a gun that I had no dealings with? You feel me? I'm not gonna tell you the truth, but I had no dealings with it. You feel me? So at the end of the day, it's like, the shit was scary. You know what I'm saying? The shit was scary, and I'm not afraid of nothing. Because at the end of the day, if y'all can do that by a picture, what else I can do? You get what I'm saying?
It's real,
That kind of
bro.
made you realize how big of a person you were
We
because people were watching other people's Instagram and
Yeah.
they targeted you.
Yeah. That's what it was. I had so much shit going on, and at the time, my brother was a house known nigga like Kodak Black. Okay, yeah, everybody know Kodak Black. Everybody know he's stepping with. You feel me? And for me being his brother, it's like, okay, shit, what do he got going on? Why do he look so fly? Why he? You feel me? Every time, yeah, okay, you feel me? You know, I don't be smelling that though. I don't be smelling that. Not by a long shot.
How did that affect your mental? Because you're living your everyday life. You're not even knowing that these people are looking for you. And then the next day, your whole life changes for 29 months.
For 32.
Oh, well, 32, my bad.
For 32 months, I did a whole 32. You know, the whole 3 years for them. It's like, okay, boom. It fucked with my mental because I had a shorty that I ain't never meet.
Dang.
I was starting a new relationship with Brown Goddess, Denisha Evans. You feel me?
He said the whole name.
That's my fiance right now too. My mother was just transitioning to a new house. You
Man.
feel me? Because we got kicked out of the other house behind the raids and and so it was like my family and friends, they didn't know how to cope with it because I'm never in trouble. Even I might go to county jail, the county, the main jail, but that's for like 2 weeks, a day. You feel me? 3 months, but it's nothing big. Little charges here, but it's nothing big. I don't slip like that. I don't move like that. You feel me? I'm a real deal sniper. You feel me? So it's like that shit really fucked with me, man. Like for real. They seeing things that was going on in the feds. It's not like state. The shit is fucked up in there, man. It's fucked up and it's crazy.
Especially in Florida.
You know?
Now, they offer you 10 off rip or like,
That's
how
what I
do you
was
get it
facing.
down to 36 months?
That's what I was facing.
Okay.
That's what I was facing. You know, the judge was straight though. She liked it and she wanted me to go to trial, but I was thinking like, I go to trial and I lose, you finna give me the minimum. You feel what I'm saying? So it's like, I don't know about that fair shit. I ain't no fair baby. Now I'm a fair baby because I'm in the system. I'm in the fuck ass system. You feel me? I ain't supposed to be in the system. I'm in the system. You know what I mean? But it's cool though.
Yeah, you did a great job keeping it under wraps because none of the blogs knew about it. We all knew you went away, but we didn't know it was because of silencing.
Yeah.
You know, the blogs find out anything.
Yeah. But you know, like I said, I'm a real good sniper. I stay in the cut. When I come out, it's because my presence is needed. You feel me? Like the first time we did the interview, you brought me out. You feel me? Like, boom, 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 bro, let's do something. Boom, boom, boom. And it was done. You feel me? It wasn't 30 niggas there. It wasn't, you feel me? We handled like business. You feel me? I'm really business oriented. I might be fucked up, but man, Poppy dude, man. You feel me?
Hey, it's Shawn Mendes, the voice of Lyle.
My bad, New. I'm gonna go back to the courtroom now. I just wanted y'all to see that part. That's on Say Cheese channel, dog. I'm about to bring the courtroom back up. That's on Say Cheese channel. So what I want y'all can hear me? Can everybody hear me? Let's go. Round off, sound off, man. Turn up. Who in the chat? If you can hear me, hit the like button. Hold on, real quick. Hold on. We back in court.
Okay, the court's had an opportunity to take comfort as well, to ponder the issues in relation to bond in terms of Mr. Martinez Arnold, in indictment 8572, and I have considered under the bond statute 17-6-1. Of course, the purpose of pretrial bonds prevent punishment for conviction, secure the appearance of the person in court for trial, and that the trial court can release a person on bail if I find that, one, they pose no significant risk of flight.
Oh, I think he finna get it.
Of the court of failing to appear in the court when required, pose no significant threat or danger to any person, community, or property in the community. 3, pose no significant
Yeah, he finna get this bond.
additional felonies pending trial, and 4, pose no significant risk of intimidating witnesses, otherwise obstructing the administration of justice. And the appellate courts, of course, would require the trial court to explain any reason for denying bond and that the denial of bond is not set aside unless there's a manifest or flagrant abuse of discretion. And that's all fairly contained in Ayala versus the state 262 Georgia 704, which is our seminal bond case in Georgia. Having considered all of the arguments of counsel and the proffers that have been made thus far, the court is of the opinion that Mr. Arnold still poses significant threats to persons and property in the community, in particular. And for that reason, and as well as poses significant risk of intimidation of witnesses and obstruction of justice. So I'm going to deny bond.
Ooh, they are done. They are done.
However, Ms. Merchant, if you should have a change in circumstances or any other conditions are brought to the court, I'll of course reconsider bond accordingly. Okay. All right. Okay. All right. Madam, you are welcome to stay. I've still got some other matters I need to take up, Ms. Merchant, but you and your client are welcome to remain on the
Hold on real quick, y'all.
on the Zoom call as well as the in present in court. Okay. All right.
Ooh, so
All right. Mr. App, sorry that it's taken me so long to get back to it. As you can see, I've had a lot of things to deal with today, so I appreciate your patience.
all right, for everybody that's just coming in, they just denied YSL Duke bond. Duke was one of the people at the house with Young Thug. I ain't gonna lie, bro. This right here showed me it ain't looking good for them niggas, bro. Cause that nigga, for me looking how cases work and what's really in your face and the facts, he was supposed to get a bond today, bro. And the judge said the stuff at the house, I can't say none of that is his, but he just got denied bond. YSL Duke. So I'm about to post something real quick. Y'all watch this. I'll be right back.
All right, and I appreciate you saying that, Mr. App. What I'm going to do is, okay, first, you have I've enumerated your motions that you have pending at this point in time. Do you still wish
Can y'all
to
hear?
have your motion to sever, or is that something that you wish to table for the
Can
time?
y'all hear?
So, and I mean, again, I said it before, but I will also reiterate.
He was supposed to get that bond, man.
I mean, no disrespect to the state. I tremendously.
Hold on real quick.
For Mr. Smith and Ms. Rosen
Can y'all hear?
is here as well, and the team. Respect and profession, I do. However, they filed lengthy briefs in response to our motions. Yesterday, they filed those responses.
Do you want some time to?
Yeah, that
On those?
doesn't give us a lot of time. And
I don't mind. Look, that's why I asked you. I mean, it's not a thing that I need to necessarily you spend. You want some more time to look at and consider that, then I'll go ahead and put that. Give you that, afford you that opportunity to do so. Would you like to to defer on all of your motions or just the motion to sever at this point in
I
time?
think we're exploring all of them. I do want to ensure that the court so listed our motions earlier today, but just so the court is clear, and the state is aware, I'm going to argue the motion to sever and, so those, argue the special demur. My co-counsel, Ms. Stewart, will be arguing the general demur, and my co-counsel, Mr. Weinstein, will be arguing the motion to strike.
Can you spell Ms. Haggerty's name just for the record, please?
Hingerty.
All right, thank
Which
you.
means K-A-T-I.
Haggerty?
Hingerty.
All right, okay, not a problem, we can certainly defer that. I think that given, where your client is located at the Fulton Jail, that Mr. Chamberlain indicated that that would probably be the 13th of October. So it will be, we'll carry that until that time, so.
And my understanding is the court is going to issue a written order on the discovery issues that were decided earlier today.
Well, I'm going to have the state draft that, and I will consider it, but they will certainly send you all a pursuant to, their responsibilities as advocates, for you all to look at before I handle it.
And also, Your Honor, just so I'm clear, all the motions the state has filed, there are multiple motions the state filed on Joe, those are going to be tabled from
That is correct. The state has a couple of motions related to it, and that is, the identity, the note-taking, and consideration of evidence, and the objection to jurisdiction. So I'm tabling those for the conference. The only one I'm gonna go ahead and start with you all collectively as a group working is that the court, was going to go ahead and do a questionnaire to assist the court with jury selection. So since the state referenced that they were going to do that, I'm going to go ahead and grant that, so that that can start to percolate amongst all of you.
Should I and the counsel for Mr. Kimberly support another majority of motions as well?
Hold on real quick, y'all.
No, 9/13. No.
So they coming back to court on the 13th.
So, yes.
Damn, I can't hear him. He ain't talking to the mic. My bad.
I'm open to suggestions. You want to say the end of October? Okay. I would say that's correct. All right, so yes, by 30.
That would be the 30th of September.
Yes. Yes.
You want the defense to prepare questions?
Yes.
Prepare a questionnaire.
That's usually how it works, Mr.
I
I mean, look, it's gonna be sent, you have questions you want me to add in, certainly, send them, and I'll, when, before it's.
Dang, bro. I thought they was gonna get that.
I'll, of course, entertain the argument, so.
I thought they was gonna get that bond. I ain't gonna lie to y'all.
Will include- No, the questions are submitted. Yes, and I'll start working on the companion. And then at a date certain, I told you all, hey, come on in, let's discuss what I'm gonna do. Identify yourself. Thank you. Okay.
Just for clarification, on October the 13th, is that an person?
Yes, I tell everyone.
October 19th is one day.
All right, thank you all, and what I'll do is then, I'll take a look to the 13th of October at 9 a.m. and we'll adjust the date. So, Mr. Kendrick, the lawyers will be back in touch with you, okay? And we'll see you on the 13th of October, okay? Yes, sir. All right, thank you, sir. I don't release you at this point. I thank you, sir. All right, does anybody else have any other business before me? Mr. Getchell? Yes, Mr. Matthews.
Good afternoon, Archie Matthews, State General, Clay this year.
Yes, sir. Given the discovery in this case, do you want me to hold you have a motion to sever, motion to suppress, and a general motion to suppress, and a motion to suppress the defendant's statement.
That is correct. And you hit the nail on the head where I'm asking you to hold on our motions. In fact, I was under the impression today that we were only going to be hearing the bond hearing. That's what I was actually noticed on. So I do want to hold until I get all the discovery, so I can determine which motions are applicable to this case and which are not.
I'm gonna put your motions back on for the 13th, since your client, where's Mr. He's in the Fulton County Jail. I'm gonna put him back on for 13 October. That is when I have the next available, Zoom, accessibility. So I'll go ahead and put him on for that date, and you can let me know. I'll notice those motions, and if you wish to still proceed with them at that point in time, then you can let me know, okay?
Yeah, sure. I have one last question for the court. Is there a case management scheduling order of sorts that we are moving under in this particular case?
No, not yet.
Okay. All right. Thank you, Judge.
Okay. All right. Anything else, sir?
That's all I've got.
All right. Unless you have anything else, then you may be excused at this point in time. Okay.
Okay.
All right. Thank you, sir. Thank you, Chris.
You got it.
All right. Anybody else on the platform I've not otherwise addressed have any other questions they wish to ask the court? Okay. If not, then some of you will be back before us on the 5th or the 13th of October, and we will send notices appropriate to everyone notifying them of those dates, all of them, to participate in this, and then we have emotions greatly. Okay.
This it? It's 4 o'clock in Atlanta. Okay, let's see. Okay, y'all. So they'll be back on the 5th and the 13th. So I want to answer some questions for some people in the chat. It's over. They're out the courthouse, but I'll answer some questions. Let's tap in. Any questions, really, life, anything else going on while we're here, let's do it. Let's talk about it. While we here, let's talk about it, man. I heard Thug concerned. Okay, I ain't gonna say that. Y'all going in. I'm gonna tell y'all why they did have me thinking that they could possibly get a bond. Damn, bro, they got some niggas in this bitch I ain't never even seen before. Bro, this shit gotta suck. Hancock State Prison, bro. Look how young this nigga is, bro. What the fuck? Hold on, let's listen to that shit real quick. Let's go back real quick, bro. Did y'all see that part?
defendants. 3 of them are not in custody yet. 2 of the warrants are halfway for signature. One, there's an issue with, and I want to be clear, the indictment is different than what's on policy. I can't change the indictment, and the clerk's office is telling me.
So I'm gonna keep it 1,000 with y'all right now, bro.
The warrant reflects the indictment. So I have 2 indictments if the court can sign them.
That ain't thug. Damn, boy. Damn, bro. This some wild shit, bro. Have we ever seen anything like this?
Okay, let me try it now. Can we get an audio check for those of you who are on Zoom at this point in time? Let me just pick one. Hey, State Prison, can you hear me?
Yes. Yes,
Okay.
John.
Okay, all right, wonderful. I'm just gonna mute you again. All right, still time. All right, Hancock State Prison. Thank you, sir.
Bro, do y'all see how young this nigga is?
Siri, can you hear me? Say that, can you hear me, sir?
Yes, John.
Thank you, appreciate it. I'm just gonna do one more check. I think I can do it now. Mr. Wright, can you hear me there, Wright?
Yes, Judge.
All right, thank you, sir, appreciate it. I think we have audio now, so let me go back to the calendar at this point in time. Position number 8, Antonio Summons, that I find on the platform. Mr. Summons, if you are on the platform, please raise your hand. Speaking for number 3, thank you, sir. Mr. Rice? Mr. Hoover? Yes, sir. Good morning. Good morning, Mr. Hoover.
All right, let's talk, y'all. Let's talk. But
Mr. Hoover, it looks like we need to arraign your client. Would you like to waive formal arraignment, have the court enter not guilty on behalf of your client's behalf, and have at least 10 days to file motions upon the receipt of discovery, sir?
all right, sorry about the noise. They out here pressure washing. I had to come to my nigga new crib and use his computer to do this live stream. My Wi-Fi messed up at the crib, so I had to come tap in. And this will be the only thing I'll probably do today unless something pop up, because I don't have Wi-Fi. I can do it from the phone, but I like to have the experience on point and everything. So let's talk about whatever is going on. I'm interacting with the chat for the people that just came in. They just denied Duke bond. Duke, this was a motion for him to possibly get bond. He's in the original Rico charge. The paperwork that first came out that we went through, that was viral. Everybody had it. It was all over Twitter. I ain't never seen no shit like this in my life, where niggas' paperwork is all online. And I'm gonna be honest right now, bro. I had some tough news get delivered during the stream earlier. I ain't gonna say his name yet. I'm just hoping it's not true. An artist that I really fucked with got picked up on the 21-man indictment, and I don't want that to be true at all, bro. Like, I really rock with homie, bro, and I feel a little bad because I've been telling even my nigga New just started listening to his music. And I pulled up today and New was listening to his music. And I talked to New yesterday. I was like, man, I'm going to call this nigga about a video he had shot, because he came with a real creative idea, bro, on this video. And I was like, hey, bro, this bitch hard. I didn't never tell him that I fucked with it. I liked it. I shared it to my Instagram story, but I never got the chance to tell him what I wanted him to do with that video. I wanted him to redo another one like it with a different concept. And I don't want to say his name yet, bro, because it's not confirmed. There was a raid, and I heard he got picked. He's part of this indictment. I don't know if he was at the raid, but I want to say like that one, that shit kind of fucked me up, bro. So it's a wicked situation to see these type of things go on, because I'm the type of nigga really, bro. I love what I do, my nigga. Like, I love this rap shit, bro. Like, I really love this shit. So for me to see any nigga get picked up on an indictment that I really know, now he not from Atlanta. He from somewhere else. But I'm gonna wait before I come out and report it because it ain't confirmed yet. I hope it's not true. Cool nigga, man. Father, all that. So I want to say this. In their situation, or in Duke and them situation, Duke's lawyer was painting the point and trying to push her point that Duke is not a convicted felon, and also where he's brought up in the Rico, where YSL Duke is in the Rico, he's already served his time for those crimes, and they were all probation. His weed charges all resulted in probation, and he was able to get past that and do the probation to where he should be able to be released on a bond. So what happened was the first indictment we saw that came out that was viral everywhere. Y'all saw it, pictures, Instagram posts, lyrics, phone conversations, all this. That was the first indictment. But if y'all remember, a month ago, probably about a month ago, they got hit with a second indictment. The second indictment was towards Thug, Duke, Yak Gotti, and one more person who was at Young Thug's house. Guns, drugs, and the machine gun. The machine gun was a Glock 45, but it had a switch on it. That's an automatic, you gonna be fucked on that. You can't have a gun if you're a convicted felon, period. But having a switch on it, you really intensifying the situation. So Duke lawyer was arguing. My client did not have a gun on him. My client only had 3 grams of marijuana on him. How's he a threat to society because of this? Every crime that he committed, he got it dropped, dismissed, or beat it on probation. And he is not a convicted felon. So when she was saying that, the prosecutors, he got stumbled up. You can look at it. His shit was stumbled. So the judge actually said, the guy tried to say, he's around these guns. So the judge like, were they in his possession though? Were any of these guns or other drugs in his possession? He said no. How far were they? He was like, it was in the area, but if it ain't next to him, I don't know what their distance is. You can't charge him with it because it's in the house. And the gun is registered to somebody else. So with that being said, I was like, hey, bro, he might get a bond. The judge still came back and denied that motherfucker. Denied the bond. So we're going to be back on the 5th of next month. And I think they said the 13th or the 18th. So I thought he was going to be able to get a bond, bro. Now that changes everything because in a regular situation, bro, they going to give you a bond for some shit like that. So it is over. I don't know if it's over, if they take a break. It's a tough situation to be in, though, bro. Because I really thought that nigga was going to get that bond this time, bro. But now they showed me the judge has made up his mind. The judge has made up his mind. These niggas are a threat to society. There is no more in between. It's how it really look, man, when your life on the line, bro. You sitting up here, letting them decide to do with your life. You sitting up here letting them to make the decision for you. Damn. The judge that made his decision, bro. I tried to save faith and, give them, like, not speak negative on this situation. But the judge just laid it out that, hey, nigga.
You registered.
Damn, man, my bad.
Man, you said 2002 date.
It's just that. I don't know what the fuck happened. I guess they ended.
Other people want.
It might have ended it. So, I thought that he was gonna get a bond, bro. I know that it looks bad. I know their court case is what their court case is. I thought Duke would get the bond because of his charges. Because of his charges. I thought Duke was gonna get a bond. I didn't say Thug. I didn't say nobody else. I thought since Duke had completed all of his other stuff, he's not a convicted felon. I thought he would be able to get the bond, man. This shit is wicked. Does anybody want to come on and speak before anybody want to come on and speak a little bit? Yeah, Duke Lawyer was speaking the facts, bro. I'm not being biased. I'm playing it. My bad on the noise, y'all. My boy Crib, they power washing over here. I couldn't come to my crib. Nah, bro, they presenting everything they got in court. Even when Duke's attorney was combating the prosecution, he was tripping up on his words, bro. I seen the nigga hand was kind of like fidgety, bro. That nigga hands was fidgeting on the paper because he didn't know what to move. I'm watching this shit live. That's the thing about watching it live, bro. You can see that shit. Anybody want to tap in? Okay, Ben, I'm gonna drop a link. You gotta come in on this link. Let's chop it up. I also want to send condolences to the people in Memphis, bro. I don't have time to really make a video about it right now, but that is unacceptable, my nigga. I don't know what the hell that weird nigga doing. That shit is lame, my boy. Ain't nothing cool about going out here killing no innocent people, nigga. You look like a clown. You look stupid. I don't know if he got some mental health stuff going on. Nigga, we don't do no shit like that, bro. All that old just going around shooting innocent people, nigga, killing innocent people, fucking with people's cars and shit. Man, hell nah, bro. That shit's some lame shit, nigga. We don't do that shit. Real people don't do that shit. Real men don't do that shit. You know what I'm saying? Condolences to those families, though, and everybody who lost somebody in that situation. But if anybody want to come up and speak on this YSL stuff, let me know any other questions about anything going on in the game in hip hop. I probably won't drop no more content today, maybe, depending on what happens after I get off of here. Damn, man, they got my nigga on the motherfucking shit, man. I hope my boy, I don't see his name on this indictment, man. I mean, I ain't see him on the internet, but I hope he is not part of this motherfucking indictment, dog. Please, man, I hope my boy ain't part of this fucking indictment. He might be good. He posted 14 hours ago. I don't know. Fuck. So, hey, man, what else y'all want to tap in on, bro? Yeah, you living out the life of crime. You gotta stop. Let me see what else going on in the news today, man. Fuck it, we here. Let's politics. I brought New Money and then took a nap. Shout out to New Money for letting me use this spot to get my grind on today. We really got the same. We brought our computers from the same nigga, our Macs. So it wasn't nothing to come up over here and set it up. You feel me? I'm looking through the news right now, seeing what else is going on. Yeah, that nigga tripped out. Ezekiel Kelly, nigga, they gonna front. Hold on, y'all. I'm looking for some shit. Shout out to Young Blue, man. He just copped a new jet. I ain't been all the way tuned in. I've been so consumed with the Houston shit. Boosie. Condolences to the family of Duke the Jeweler. I don't know if y'all saw that situation with Duke the Jeweler. He got killed out here in Houston. He was at a Dice game one night, and then he went to the Boosie concert, and he was killed in the parking lot walking to his car. I'm assuming that they tried to rob him. News reports report that it was a robbery and shooting. He was actually from Chicago. And I tell you this, man, if you go to any city, this is not just a Houston thing, but it is a Houston thing, but it's not just a Houston thing. Any city you go to, bro, you know, and a nigga don't know exactly why homie was killed or what it was all about, but make sure, bro, like, if you gonna have on a bunch of jewelry and you gonna have all your ice on and the spotlight is on you, especially if you go to a concert. If you go to a Boosie concert in Houston or any rapper concert in Houston that's at a club or like a hood venue, the street niggas is there and they're watching. Some of them are never off the clock. Some of them plot, sit on niggas and do their job and do their homework. Some niggas, they clock in at any time, meaning if I see a lick, I'm gonna go for it. If you a nigga that look like you from out of town, they don't know you, or they could have been watching your Instagram, bro. It could have been. It could have been a nigga from the Dice game, or it could have been a nigga who been watching his Instagram and was just sitting on him. Oh, he was there. Oh, he at the Boosie concert. Or a nigga can do this. I'm not trying to solve the crime. I'm just telling y'all different scenarios. A nigga could have seen him take that picture with Boosie on Instagram and said, you know what? He gonna be at that Boosie concert probably tomorrow night. He go there, he see the nigga there. Okay, we just gonna sit in the parking lot and stay on that nigga. See where he go. Follow him. That's how I go. Nigga ain't even had to be at that dice game to figure it out. That's what I want to be very clear. Nigga ain't had to be at that dice game. That nigga could have just been out, nigga. He could have got killed just by a nigga who was out. Just because he put everywhere he was at on Instagram. Y'all get what I'm saying? If you in the town, you plan on going places, and you standing next to people, you kind of let niggas know what moves you make. Because all I'm saying is it don't have to be nobody in that room. This could have been a nigga just on his phone paying attention, like, okay, what that nigga doing? Oh, okay. We gotta get him. Fuck it, we gonna get him. God bless his soul, though, man. We see this happen a lot. This is a big thing in Houston. It's a big thing everywhere, though, bro. Niggas be trying to take niggas down for their jury. It's a part of this shit. I just seen said he got robbed for his jury. Cashier Quan out of Detroit. Cashier Quan got robbed for his jury. He said he got set up by his old homie. Anything else, y'all? Condolences to everybody we lost. I've been consumed with the Zero and Trey situation. I got one more clip coming with that. Then I'll probably drop some other shit. We'll see what other news has jumped off. Aries Spears responded to these allegations. I didn't have time to make that today because there's so much other shit going on. Then I lost my Wi-Fi, but they say they coming to fix that tomorrow between 8 and 12. Between 8 and 12 tomorrow, the Wi-Fi gonna get fixed. So we'll see. I'm gonna try to drop 2 videos tomorrow, and I'm gonna try to continue my interviews next week. I'm gonna try to get back on some interviews next week. I got a few interviews in the tuck, a few vlogs. All this shit is coming, all types of content. Studio 56 podcast is gonna be on Monday on the Studio 56 podcast channel. I seen that situation with Quando Rondo too. A lot of people covering it. And I'll be honest with y'all, bro. People are it is news. I want to be clear. In the aspect of news, it's news. It's entertainment. It's entertainment. No matter how you like it, no matter how you feel about it, no matter how y'all think. Once it makes the internet, it's news. It is for everybody. This is why I strongly suggest you don't put your stuff on the news or the internet. Don't put your information on the news or the internet if you want to keep it private, because now everybody can form an opinion. So for Quando Rondo to go to his Instagram story and let everybody know his stance, it's not playing chess. Life is a chess game. What you did was make yourself a bigger target. Not even for street niggas, but for the internet. Keep it to yourself and just move strategically. If you're not rocking with niggas no more, just don't rock with them niggas, but don't make a statement about it. When you put a statement out there, that means that's what you're wearing when people see you. And you should make statements. Statements that need to be made, they need to be made. Statements need to be made. You know, sometimes you got to clear the air and clear the room and get shit understood. So I'm with the making of the statements, but know what statements to make. Never make a statement that can harm you when it comes to street shit or real life shit. You signed up for this organization and this team. When you get put in it, they tell you from day one, this shit for life. Now, we know gang life and street life is never fair. And I want everybody to understand that, bro. Don't ever jump in the streets and think that they're going to be fair. Don't ever think that any street nigga you do business with on some street shit is supposed to be fair. There is no such thing. It's just not that. And even the niggas you deal with might be fair, but it's a nigga that one of them might have dealt with that ain't gonna be fair. It's always somebody not willing to be fair. The streets ain't got no rules, bro. And niggas have got to understand that. I don't make the rules. I learn them and I abide by them. I play the rules because you got to. Stay out the way. If you in there, you gotta find you a transition, my nigga. So when Quando Rondo went on there and said that, bro, he put a target on his back bigger than the one he already has. And let me tell you like this, bro. We seeing some shit that we ain't supposed to see. It's a lot of people speaking on that situation who I feel, even with me not being the nigga that's running the streets and breaking the law and claiming no click and no game, I still feel that you should be qualified to have experience if you're gonna speak on this gang banging stuff, bro. Or just not be a part of the gang, at least come from the background of the culture of the streets. But it's like, now the game is so wicked, I'm seeing nerds, and I'm not even talking about niggas that's like known. Like kids in the comment section have an opinion about Quando Rondo not claiming his gang no more. Like little nerds in the comment section. Like, nigga, who the fuck are y'all? Like, you know what I'm saying? True, on gang time, street nigga time, they took an oath and they signed up for something. But I'm like, bro, who the fuck is this little fucking goddamn what's a white boy name? Fucking Peter. Who the fuck is Peter to be commenting on some Quando's no longer neighborhood? No, my nigga, like that ain't what the game is supposed to be. But when you put it on the internet and you place everything, you post everything, you bringing these niggas into your business. If I was on that type of time, I would have just not said nothing. I would have kept my people around me I rock with and been down with them. You know what I'm saying? Like, hey, I rock with you. But hey, man, we ain't fucking with all them niggas. We gonna move strategic, bro. Duke argument was good. I feel like Duke should have been able to get a bond. I'll say that. I feel like Duke should have been able to get his bond, but they denied him. So, hey, it is what it is, bro. Duke should have been able to get a bond. My honest opinion. My 1,000% opinion, Duke should have been able to get a bond. That's how I feel. Based off of what he's charged with in his history, he's not a convicted felon. All his other cases, he's completed everything. But man, the witnesses, bro, they worried about the witnesses, dog. So that's that. Does anybody else want to tap in on anything else? I'm gonna drop part 2 of that clip with Mike D tomorrow. The last conversation we had, part 2 gonna come tomorrow. Put that out. And then I'll put out whatever content, whatever else is going on tomorrow. I'll cover that. I got an event to go to tonight. Actually, she was great. We locked in though, man. Make sure y'all stay on y'all pivot. More shit coming, more videos, more interviews, all that shit, man. Anything else before I tap out, man? I be wanting to interact with y'all, but y'all niggas ain't typing shit, so we gonna tap out, man. Anything else, any comments, anything anybody want me to speak on, let me know. Right now, type if you want me to speak on something and give my opinion on it, or tell you what I think about it or whatever, or some facts. Now I'm saying, I'm talking about in the court of law, bro. My personal feelings about if a nigga should be in jail or not, that matters not. I'm talking about a bond. I'm not talking about homie doing jail time, you know what I'm saying? I'm not speaking on should a nigga go to prison or not. That ain't for me to decide. That is not for me to decide should a nigga go to jail. That ain't for me to decide if a nigga should be locked up. That's up to the system. All I'm saying is that in the court of law, I gotta lay the facts out. Okay, it looks like he's eligible for a bond, nigga. That's just that. He's willing to give up full house monitor, be a full house monitor. Y'all got it. Y'all gonna have all this phone stuff. Y'all gonna better watch all his moves. It ain't shit he can do. I ain't gonna lie though. Somebody on this case, the last time they were free, it's gonna be the last time they were free for a while. Only thing that can save niggas now is God. But we out here, man. We tapped in. I appreciate y'all tapping in. Make sure y'all subscribe to the channel too, bro. Hit the like button too, man. If you ain't hit that like button, hit the like button, bro. Turn us up one time, man. We working, man, every day. Content. All types of content. All types of content every day. So if you was free today, man, if you watched this today, hit that like button. Turn us up. Ain't no reason not to. Damn, I ain't giving 174. Come on, get that to 200. We got 289 here, man. Hit that like button, man. What's the question, Champs Bag? What's good? Do you think someone causing hits should be out on bond? Do you think someone causing hits should be out on bond? Nah. Bro, Duke did not call no hit in this case, bro. I'm talking about Duke. If you break the law, bro, you gotta deal with what you gotta, if you in a gang and you trying to get people killed, yes, rest condolences to Queen Elizabeth. If you trying to get people killed and you get caught doing that, bro, you going to jail. That's just what it is, nigga. You gonna have to go do your time. Yep, you might be right about that, Miss Price. But that's the only way you gonna get out now. I'm just keeping it real. Zero J ton paperwork. Like I said, hold on, let me answer homie again. I want to make this very clear, bro. If you are out here killing people and shooting people and you get caught, nigga, you are going to have to go do that time if they can prove it. It don't matter what I think. It don't matter what you think. It don't matter how you feel. If they got the evidence, nigga, they got the evidence. You was fried. How big Enfield don't matter. I'm speaking specifically on Duke from what his lawyer presented and what they were saying. She beat the DA today. She made the DA case look bad today. But because their reputation, they were denied bond. But if it was person for person without YSL on top, that nigga would have been free, bro. Yeah, they say Mystical facing life or some shit. It'll be good for the community for no crime, my nigga. But I'm gonna tell y'all like this, and I want y'all to take this how you want to take it. I want some answers in the chat right now. Fuck it. How many, let me see something. I want to ask y'all this. I need 8 more likes, man. Turn them likes up. Get nigga to 200. Fuck it. Yeah, get that bitch to 200. We don't be even tripping like that on no likes. I don't be saying subscribe all day. I be just giving the content straight like that. I'm thinking about getting a Patreon. No, I got to holler at YouTube. They've been tripping on nigga shit, so I might go ahead and get this Patreon. Let me tell you like this, bro. Snitching on people, that's not a thing of honor because you're not telling to make the community better. Champs bad. Snitching is not telling to make the community better. Snitching is to save yourself. That's why it's unacceptable. We don't rock with snitches because snitching is about saving yourself because you don't want to face consequences for your action. That's not cool. That's snitching. We ain't pushing no snitching. What I do want to say, for people who blame the problem in the community, I hear a lot of gangs, drug dealers, killers, and rap music. People think that's the problem with the black community, right? I feel like it is a problem. Do y'all feel like, who feels like that? Let me ask Champs Bag, and let me ask Champs Bag. I'm gonna ask you, Champs Bag. What's the biggest problem in the black community that holds the black community back? Champs Bag. Champs Bag. Let me know something as soon as you hear that. I know the time be a little bit delayed. But give me an answer as soon as you hear that. What is the biggest problem in the black community? What holds the black community back right now? Violence. Champs Bag. What they have done. What else? Anybody got anything else? What's the biggest problem that's stopping? Let me ask y'all this like this. What's holding black people back from being better and in better positions? All right. For anybody who wants to blame everything on gang members and street niggas and rap music, let's make one thing clear, bro. And there is no debating this. Just know, bro, they could take every street nigga, every gangster, every gang member y'all know off the streets, nigga. They could take every gangster, every street nigga, every dope dealer that y'all know off the streets. Guess what? The black community does not increase in position. We still don't get better in position. It gets quieter, it gets safer, yes, and we need that. We need that for these kids, bro. I'm not for seeing kids getting hit in drive-bys, this crazy Memphis nigga running around shooting people. I don't want to see that shit, bro. Nigga don't want that. Nigga don't want innocent kids getting hit. Nigga don't want to see innocent people die. Nigga don't want to see street niggas killing street niggas. But just know, nigga, if they take all that shit away, the music, they can take rap music away from us right now. But let's say they take, because rap music get a lot of blame. Keep everything going on. They take rap music away. Nothing in the streets stop. People don't realize the rappers are rapping about what's already going on in the streets. It had been that way. When NWA started gangster rap, they were rapping about what was going on outside their front door. These things were going on before a gangster rap song got created. The cycle had already begun. We get the cycle from the Italians. The Italians didn't have rap music to listen to when they started pushing this mob, gangs, and extortion. And when they created the Rico Act, the Ricos was not created for niggas, bro. The Rico was not created for us. The Rico was not created for us, nigga. The Rico was created for Italians, nigga. Just know that. And I want people to understand that. Yes, drugs in the community hurt the community. A lot more people would be in better positions if they did not have drug problems. But guess what? You take away the drug dealers, you're going to have more robbers. It is cool to be a law-abiding citizen. What are you talking about? Being a law-abiding citizen is cool. If you let somebody tell you you're not cool because you follow the law, then you will. That's called peer pressure. Peer pressure. Following the law ain't the only form of thing that like people can look at and say that's wild. Them Italians did not have kids, rules, and codes, my nigga. Them Italian niggas used to kill and snake their own partners. And a lot of them Italian niggas, when they got jammed up, they told, nigga. They had certain rules and codes they followed, but they didn't have too much honor themselves, bro. All them niggas motherfucking got the flipping and telling. They didn't want to do that fucking time, nigga. So I don't know. I'm just telling you how this shit go, nigga. If you think an Italian ain't never killed a kid or a woman, you crazy. Don't let them push that shit on you. You think a mobster ain't never killed a woman or a kid? Crazy. Niggas don't be intending to kill, niggas just be on some crazy dumb shit. But yeah, man, I'm out though. We're gonna tap back in with y'all. I'm trying to go take care of some business. And appreciate y'all for tapping in, man. Make sure you subscribe to the channel. More shit coming, more videos, all that, man. 1,000. Stay over your pivot for shit show. Stay up, man. Think we'll be back on the 5th, they said. You've been in support for these fake ass street code nonsense, bro. Champ's bad. That is a lie. And I don't know if you a troll, but I'll give it to you today. Big Ant has always said he does not follow the street code. That's documented. Big Ant has always said he's not following the street code. I don't break the law, nigga. I'm not a criminal. Have I broke the law before? Yes, nigga. Everybody breaks the law. But I'm not a criminal. I'm not committed to a life of crime, nigga. I'm on YouTube every day, nigga. I got my own clothing, my nigga. I got my own brand, nigga. All I say is when I talk against everybody putting blame on the streets, niggas think, oh, you standing da-da-da-da-da. Nah, nigga, this is facts, nigga. The news got you niggas mind fucked. They got you niggas mind fucked thinking the only problem in America is black on black crime, nigga. They got a white on white crime going on right now, nigga. Ukraine and Russia. You got white people killing Russia. I mean, you got white people killing white people in Ukraine and Russia, nigga. Right? You got Mexicans killing Mexicans in Mexico. Right? We just got the most entertaining soundtrack to our culture. Black on black crime is not the number one cause of death in the black community. It's number 4. Just know that. Just know that. Black on black crime is not the number one cause of death in the community, nigga. Just know that. Take that with you, nigga. Yes, nigga, as I always say, it's a problem. But see, you niggas really just want a nigga to get on here and disrespect and call rappers out their name. That's nothing but entertainment. That ain't solving shit. That's just entertaining you niggas. You want to go get entertained? You got a lot of people on YouTube doing that. Big Ant gonna speak the reality. Them other niggas, they doing their shit for entertainment. I'm gonna come over here and give you the real, nigga. And if you don't like the real, you don't like the real. That's upon yourself. %37% of the white women in America, 37% of abortions in America went to white women also. 37% of abortions in America are white women. 37% of abortions in America are white women. This is a fact. Rap music is entertainment, my nigga. Rap music is nothing more than entertainment, and you need to raise your kids that. Guess what, nigga? If they wasn't getting entertained through rap music, they get entertained through movies. A lot of these niggas was rapping about shit they seen in movies, Menace to Society, shit like that. Shout out to Josh 07. We out though, man. Y'all can take what I want to say, or y'all just want to be combative. And if you one of them weak niggas, if you a weak nigga, the cop out. If you haven't opened up your mind and really seen what's going on and did real information, if you just want to blame it on rappers, keep coming on. I love rap music as entertainment, my nigga. I'm not out here trying to kill nobody, as I said. Straight up. Y'all ever seen, we got one nigga who went and shot all these people in Memphis on some weird shit. That happens every once in a while where you see a nigga go on a crazy shooting like that. But this kid went and shot up this school of babies. What was his motivation to get out here and murder? Babies. Ain't no rapper said go to a school and shoot up the babies. Ain't no rapper said that. Ain't no rapper got in the song and say you need to get a gun and go to a school and shoot up the kids. Ain't no rapper said you need to go to the the grocery store and shoot up all the people up in there. Ain't no rapper said that. Ain't no rapper said go to the church and shoot up these people that's helping you during Bible study. Rappers say crazy, wild shit in they lyrics, but it's never told, hey man, go over there and do this and go, nah, my nigga, knock it off. Whatever. We out though, man. We got more shit coming, more videos, all this shit. 1,000, stay on your pig for shit show. Subscribe to the channel.